paragraph 1.
You see, it's not an enabling provision in the sense in which we conventionally call enabling.
The choice part of it is
Because
enabling.
Enabling provision is like Article 15.
That's right.
Where you have the choice to make a provision. 30 is not enabling insofar as the state is concerned. It's an obligation on the state to recognize the choice.
Enable the minority. The choice part of it.
So long as
the
you
higher
say
dimension.
enabling provision in relation to conferring a choice on minorities, it's...
that's right. That's what I went to.
It can't be that I as a state can either decide to grant or deny you that status.
I'm not talking, I'm talking about a minority.
Therefore, the words as well is may not be appropriate. If I can use, permitted to use that word.
Deliberately, in the sense that the choice part is available to every citizen.
Yes.
But the higher status is given to a minority. Therefore, I say it enables them to reach a level beyond the other common consideration. That's how you put it. So, paragraph 3. In the absence of a legal competence to establish a given class of institutions.
Just read the
question is, can I go to paragraph 4 and 5?
Can we go back to your second sentence of para 2?
Yes. In order that an educational institution of a particular character or a class could be established by any person, minority or otherwise, the first prerequisite would be the legal competence or authority to establish that class of institution. As we go further, I will give further explanations about it.
Go ahead.
Right. So then I go to para 4. Under the constitutional scheme, the power, competence, right to establish educational institution can be located only under an authority granted by a competent legislation. For instance, entry 25 talks about education. Then entry 14 list 2 talks about agricultural education. Similarly, entry 64 talks about institutions of scientific, technical education and are treated as institutions of national importance.
There is list 1. Huh?
That's right. Then prior to the Constitution, schools, colleges, other teaching institutions were established by societies or trusts by reason of enabling authority granted under the Societies Registration Act 1860 or the trust law to act towards the promotion of literature, science, fine arts, and for the diffusion of useful knowledge. Educational institutions such as schools and colleges are tools and instrumentalities in the pursuit and promotion of such activities. In other words, the competence to establish educational institutions of the above class towards imparting knowledge on the above-mentioned fields of study was made available under the said legislations. I'm talking about the competence. Now, paragraph 5. Prior to the Constitution, there was no other legislation that conferred competence on any set of persons to establish a university as such. There was no legislation that conferred competence to establish universities. In the absence of a law conferring or granting competence to establish a defined class of institutions, namely a university, the question of establishing a university did not arise. The Aligarh Muslim University is a product of a standalone legislation enacted by the then existing provincial legislature. The antecedent events, namely the establishment of Mohammedan Anglo-Oriental College, sought to be connected with the coming into being of the Aligarh Muslim University, cannot be said to be any part of the competence to establish the university as such. The Mohammedan Anglo-Oriental College was set up by the Muslim community, deriving its competence granted under the enabling provisions of the Societies Registration Act. That legal competence to set up educational institutions such as a school or a college cannot be extended to legal competence to set up a university. In other words, the power to establish a given class of educational institution must be granted under a statute. Prior to the Constitution, there was no power or competence available under any legislation either to establish a university or to convert a school or a college into a university. Consequently, the community of persons who had set up the Mohammedan Anglo-Oriental College did not have the competence to establish a university, and Aligarh Muslim University was not established by them in the above legal sense and understanding. Establishment of a college is different from establishing a university, and the one does not and did not merge into the other. Ashish Basha rightly understands this position And rightly did it hold, since the university was not established by the Muslim minority, it did not have the right to administer it. Then, in order, therefore, that after the coming into force of the Constitution, a minority community can claim the protection of under Article 30, it must first have the legal competence to establish a particular class of institution. The Societies Registration Act, like the law relating to trust, continued to be part of an enabling legal framework, by reason of which schools and colleges can be established. There must therefore exist a similar enabling legislation that either enables or facilitates or grants competence to establish a university. The scheme of the University Grants Commission Act, to the extent it regulates all matters relating to universities, including deemed universities, is comparable to such an enabling law. In the absence of a competence or authority granted or conferred under a law to establish a university, no person, whether belonging to a minority community or otherwise, can establish a university. The words educational institutions of their choice cannot be construed by itself, conferring an authority to establish any class of institution, regardless of a legal competence to do so. The authority to establish a given class of institution must first precede and be traceable to and be located under an enabling statute. The choice aspect of educational institutions will then follow. Within the scope of an enabling legal framework, which may confer the authority to establish institutions, the choice aspect will be unfettered and free. And this is the essence of Article 30. So neither prior to the Constitution nor under the Constitution, a minority community was clothed with the authority to establish a university. In this legal sense, no infirmity can be attributed to Ashish Basha. The unfettered freedom to establish educational institutions of their choice does not extend to the grant of exemption from the obligation to abide by other constitutional demands and requirements. For example, the obligation to honor provisions relating to reservations or matters relating to regulations or appointments of teaching and non-teaching staff, etc., and including general regulation relating to standards and quality of education. The choice aspect of institution does not exempt the minority from constitutionally sanctioned regulations or constitutional prescriptions, which are themselves as important as the choice, as long as the state does not impinge on the choice and which the state cannot. Article 30 is intact. The claim raised that Ashish Basha has wrongly interpreted the words establish and administer is misconceived. The question is not only of disjunctive or conjunctive reading. The fundamental question is one of the competence or the authority to set up an university. That being so, there is no warrant or need for reconsidering Ashish Basha, as it has no application to any post-constitutional institution, including an university. Therefore follows that for the purpose of Article 30, educational institutions need not necessarily include an university, and such an educational institution is subject to relevant regulatory regime. For the argument, I'll just conclude by a few more. If you go back to the history of granting degrees in England, from 13th century onwards, Oxford, Cambridge, all those universities.
One accepts if one goes by the tenure of your arguments, therefore, if a legislation is today made that school can be only established by this method, by registration under this act, then the right under Article 30 will also not be there. Suppose tomorrow, like the UGC Act, we have another legislation which says that the schools will be only established if you register under this particular act, then that right will be also under Article 30, fundamental right under Article 30 will be also diluted to that extent. That choice will be then diluted.
Therefore, the whole question of a choice will have to be seen within an overarching legal framework or a constitutional framework. Constitution provides for an overarching framework. So statutes come in and say that this is what you will do. These are the kind of educational institutions that set up. That's why we're talking about a character, a class of an institution. So we did not all those judgments prior to, for instance, even St. Stephen. The court did not go into the question, where is the legal competence to set up an institution? Does it flow from Article 30 by itself? Perhaps the answer would be no. Article 30 comes in at a point of time when the competence part of it is answered. If it is answered well, within the broader legal framework or constitutional framework, my choice is unfettered. But to
So according
convert,
to you, in the absence of an enabling legal framework, there is no choice within the meaning of Article 30.
no, therefore, Article 30 premise on the availability of a legal framework. Otherwise, it will be a vacuum. Article 30 envisages it because there's a history about setting up institutions, including universities.
Will it not make it then subservient to a statutory legislation?
No, that's why we were caught into a circular argument. We are trying to come out of that. The argument, therefore, is my choice will itself confer an authority to determine what will be the nature of a class of an institution. So, but in the absence of a defining framework, a legal framework, the choice will remain very abstract. It will have no social relevance and importance. Therefore, you can work wherever you are. You must work within the broader enabling legal or a constitutional framework. And within that, what I want to do, whether I want to have institution A, B, C, or D, and that is my choice. And how that choice will enable me to, exist as a minority is not a concern of state at all. That is where the unfettered freedom comes.
Pre-Constitution, AMU was set up under the 1920 Act.
Logically.
Post-Constitution, are there any universities which today have have recognition as minority institutions
No.
post-Constitution?
No.
Something which is
The whole idea of-
Just, sorry, interrupt.
Yes, I'm sorry.
Probably after the Minorities Education Act 2005 and 2010, it's possible. Because there
Let
is
us
a
look into that
specific-
law. Let us look into the law just briefly, and then probably that will answer some of the questions.
That is possible.
And that will probably also support what I'm trying to point out. I'm not saying even
But your argument, if accepted, will mean any university set up by a.
I'll just pick up two provisions of the act. Yours kindly, it is PDF. Was putting some query. Yeah, I'm sorry.
2005 and then subsequent amendment in 2010
Yes.
with regard to minority education. Then it is possible to set up, because once you get the status from that
Yeah, Lordship.
under the said act, then obviously you can get it. But that was pointed out by Mr. Sybil during the course of argument.
I heard so,
But
yeah.
prior to that, prior to 2005, therefore it was, according to you, as far as university is concerned, there cannot be any minority university.
No, let me close my eyes to a statute like that. Let's suppose Parliament enacted a different law, conferring an authority to set up universities on any citizen whatsoever. And then brought about limitations on that power to set up a university. The story would have been different. So therefore, to say that Article 30 by itself is a reservoir of a competence or a power to set up a university. We are not talking about Ashish Bhasha. We are not talking about a future implication of a deprivation of an educational institution. Therefore, if we stray beyond that, then there are some problems.
your argument, if it is stretched, will apply to every educational institution.
That's true.
That according to your argument, it wouldn't then only apply to university. That unless there is an enabling legal framework, you cannot set up any educational institution in India. If your argument is right.
Yes,
You
yes.
can't set up even a primary school. Your argument will apply to a school as well.
That's true. That's what I'm saying. Before
So according
we
to
have
them,
today a
the
plethora of
Article 30
legislation.
right- the Article 30 right is contingent on an enabling provision of legislation recognizing
There are,
that right in statutory terms.
let me say the enabling legislation may have two components. One, to enable, to set up number one, to regulate what you do. So the
Regulation, there's no difficulty.
many,
Regulation, there's no difficulty. Enabling regulation, which says that, look, you have to have so many teachers, you must have so much of reservation, you must pay your salary, teachers' salaries at a rate which is prescribed by the union government, that you will get aid only if you fulfill these conditions of infrastructure. There's no difficulty about that. Problem about your argument is because once you say that your right under Article 30 is contingent on an enabling legal framework, that will apply to every right, every matter of choice under Article 30.
That's right, that's right. But then to say because it will apply to every citizen, then how do we locate Article 30, the importance of Article 30? Then we need to depart from that regular framework and say have something special for Article 30? My answer would be no. Therefore, the competent to set up a particular class of an institution, what we are trying to talk about. We're not talking about a university in the abstract. Any class of an institution, you will have a legal competence because every attendant consequences will follow with that competent.
And does it make a difference whether the institution is set up by or under a statute?
I know it has created some
right? Because by a statute, you can possibly say, as in the case of AMU,
in vice degree college.
that it has been set up by this statute. What about a university or an institution? We forget the university issue. You set up an institution under a statute.
I'll just give you examples. There are some states which are called universities legislation. Karnataka, Kerala, they have this university legislation. Under that act, you can set up a university. Or there are private universities. I want to set up a university, but I can't do it on my own volition. There are any number of private universities. The state legislature intervenes. So in the absence of an intervention by a legislature, even private universities cannot come up. Therefore, the competence part of it, either a legislature intervenes or a law intervenes and provides you and gives you that competence. It's very important. Therefore, prior to 1920 Act is where the legislature intervenes, I am setting up a university.
But does the fact that the legislature, you rightly gave the example of, say, legislation in the states, which has the standalone legislation, providing for the establishment of a particular university in a state. Private universities have been established in Tamil Nadu, for instance.
Any number of private.
Any number of states. Haryana. So many universities have been established under deeming legislation of the state governments. Now, does the fact that the university has been established by legislation of the state by itself amount to a denial of the right to claim minority status?
No, in a given case,
does the fact that the university has been, institution has been set up under a law amount to a denial of its right to claim minority status?
Right.
If the answer is in the negative, then when do you say that, well, your minority status cannot exist?
May I put it the question?
Suppose there is a society. Suppose there's a society which is established by a minority A, whether it's Zoroastrians, Jain, whether it's linguistic or religious minority. That minority then seeks to set up a university. A law is enacted by the state legislature providing for recognition as a university, that the university is set up. Now, the institution itself, the foundation is by a minority. The society is a minority society. The state legislation confers upon it the character of a university. Does that by in itself amount to a denial of the minority status? Two, suppose there's state legislation which allows for the setting up of universities, right? And a particular minority seeks to set up an institution within the purview of that legislation.
My answer
would that by itself lead to the denial of minority status?
My answer to that, now that there is a law occupying that field, Minority Educational Institutions Act, so that will address all these questions. And even that, let's only look at two provisions of the Act, Section 10.
Let's see the Act. Where is it?
It is volume 4A, PDF, the Act begins at PDF page 221. At page 223, solicitor's note on this act is fairly exhaustive. He will deal with it. But just want to point out, say that 10 and 10A. 10 begins with this subject to the provisions.
Mr. Solicitor, sorry, Mr. Attorney, is there any university established minority institution, university established after 1950 till 2010,
No.
50 to 2010. There's none.
They're all schools, colleges, deemed universities under the UGC.
After 2010, obviously with the amendment made in the act,
There. Therefore, section 10 talks about subject to the provisions contained in any other law for the time being in force. So this could be a law relating to regulation. This could be a law providing for certain requirements relating to establishment. It could be any law.
You're right, Jamshid. I was just saying with 2G.
There is. It will show me that. There is that. No. Can it be just shared? Some about this English position. It's a. You said it.
The right under Article 30, in certain areas, as our law has evolved, may well be conditional or contingent upon provisions of a regulatory statute. For instance, the right under Article 30 to establish and administer institutions of your choice, when you seek recognition, that recognition is contingent on provisions of regulatory statutes. When you seek the award of degrees, that right would be contingent on your complying with provisions of regulatory statutes, which are intended to define what the course of study should be, what should be the length or duration of the courses. When you seek to get aid from the state, there would be regulatory statutes which would define what is the nature of staff that you are going to engage. Will you engage people who have basic minimum qualifications? If you are a law school, that your staff must have passed the net set examination, right? If you have to appoint a professor, that professor must have completed a doctoral degree. Years of experience for movement from, say, an assistant to an associate professor to professor, so on and so forth. Therefore, there can be no manner of doubt that the right under Article 30, the exercise of the right is contingent on compliance with regulatory provisions. Those regulatory provisions ensure that the true character of an institution as an institution of excellence, as our court has said repeatedly, is maintained. Second, that even minority institutions do not fall below a national standard in terms of the quality of the students which you admit. That they must all pass the CLAT exam for admission to law, or they must all pass the NEET examination for admission to medicine, that they must pass the JEE for admission to engineering degree courses. So regulatory statutes can define the minimum qualifications for the body of students, the staff, and the quality of the infrastructure which the institution must maintain in order to gain recognition. No difficulty. Now the law has made that very, very clear. Minimum salaries, for instance, Frank Anthony Public School says that. But can the right to establish an institution itself be contingent on recognition by an enabling statute? That your argument seems to be overbroad.
I'm not saying recognition by
because
enabling.
Because what you have said in para the choice, para 9, the choice aspects of institutions does not exempt the minority from constitutionally sanctioned regulations or constitutional prescriptions which are themselves as important as the choice. No difficulty. Regulatory provisions the state is entitled to make. I don't think any minority today can say that I am exempt from regulatory provisions. But can you say that, look, your right to establish yourself as a minority institution itself is contingent on enabling provisions in a law? Then you will be making a constitutional right subservient to a statute. The Constitution can do it. The Constitution can do it. We are not saying that the Constitution, if it has done it in a given case, that provision is bad. But it doesn't do it.
I think I'm not trying to convey this proposition that recognition of setting up an institution is part of a regulatory, and therefore it is subsumed within it. I don't propose to say that. What I'm saying is, before anybody can set up an institution, you must have some authority of law or a competence or a power available to you under some law. You can't say, I desire, therefore I set up.
Undoubtedly. For a moment, we concede that point.
Right.
But your argument that before you set up an institution, there must be an authority of law. Even if you want to set up a primary school, there has to be an authority of law.
That's right.
Some law in Uttar Pradesh, Maharashtra, Tamil Nadu, where you are allowed to set up.
So we call
But does that by itself detract from your right to establish a minority institution within the framework of the law?
No,
or to put it differently,
within the framework of the law, then the choice
Right.
is entirely there.
Right. So, or is it your argument that once there is a law, the moment you establish the institution under the law, you lose your right to claim minority status?
No, that's not what I will follow from what I'm saying. But saying once you
Or
have
that
the
your-
authority,
or that your right to claim minority status would be contingent on the law recognizing your right to claim minority status.
I
That
don't
I'm not
think
sure
that will
with-
follow from my submission.
Ah.
I'm only trying to narrow down a proposition that before you set up any institution of a particular class of institution, where will you derive your competence or authority? If that competent authority is lacking, you can't say independent of that competence, I still have a right to establish.
Fair enough.
That's all what I'm trying to point out.
Right,
Therefore, Ashish Basha came prior to the Constitution. We don't have Article
But
30.
can the law say that because you do not have a right to establish an institution absent an enabling provision of law, and now I have an enabling provision of law, my enabling provision of law is contingent on your not claiming minority status. Can you do that? No. That will be violative of Article 30.
That's not what I tried to. No, I'm not saying. So it's therefore in the narrow context of Ashish Basha, I think this is what probably one would look at. And I was trying to point out in England, all those universities came by a charter,
थोड़ा सा ऊपर
degree,
जाइए।
award, just.
ऊपर नहीं, नीचे नीचे। थोड़ा सा नीचे।
So in a sense, therefore, even today, the University Grants Commission Act, it could have probably been a different legislation. It could have been a legislation conferring authority on any citizen, including minorities, to set up universities. But it did not do so. It is again enabling legislation that if you want to set up a university or to become a deemed university, you fall within this requirements in a regime. So this is, older universities operate under a royal charter. Some of these charters go back many centuries. The universities of Oxford and Cambridge received theirs in the 13th century. In Scotland, so and so granted theirs in the 15th. A number of new universities are created following the two acts of parliament. In the 1992 Act is Higher Education Act, is more or less corresponding to the UGC Act. And then further Higher Education Act authorized the Privy Council to specify providers of higher education as competent to award and taught and research degrees. Therefore, the question of degree, we are talking about that. So who can confer a degree? Why can't the person establishing a college confer a degree? For that part, again, there are certain competences available to do something in the field of education.
Right. You've got the point. Thank you, Mr. Adendra. Thank you.
May I add something?
In rejoinder, Mr.
Para 22, 92, even if regulations are invasive, they will fall violative of Article 30. For example, in St. Xavier's,
Head of the institution. I'll give you a classical example. Our court has held that you have an unfettered right to appoint the head of the institution.
yes,
Right? No law can say that the head will be chosen by a panel consisting of, say, the vice chancellor, a professor nominated by the vice chancellor.
right.
That is clearly violative of Article
even
30.
regulations cannot be invasive. Lily
That's what
Korean
I'm
says
saying.
you dismiss somebody, you can't say you require the permission of the vice chancellor.
So, for
Struck
instance,
down.
I'll give you an example. See Section 5, there's an act in Maharashtra called the Maharashtra Educational Institutions Conditions of Service Regulation Act. Section 5 says that the right to appoint a head and any any other two teachers is exclusively given to minority institutions. Because our court has said, head, you cannot say that I'll impose the head on you. There's an unfettered right to appoint the head. The vice chancellor can't say that I will, vice chancellor of a university which is to which that institution is affiliated. Vice chancellor cannot say that, well, I will constitute a committee to appoint your head. Our judgments have consistently held that head you have to appoint because the head of the institution decides that determines the character of the institution.
Well, that's the point I was making.
Yes.
Yes,
Mr.
degree
Solicitor.
college reference, you'll just make a note of that about by or under. It has an exhaustive.
Which one?
Vice degree college.
Vice degree.
The 1976
Justice Bhagwati's judgment. No?
It is perhaps it is.
Yeah, Justice Bhagwati's.
Which judgment? It is the Vice degree college. Lakshmi Narayan was the executive committee of Vice degree college.
Vice, yes.
Yes.
Vice degree. It's there in our complaint.
Is that a compilation? Yes, citation.
Write down certain problems. Write them in basic.
It is Vice degree.
That
Yes.
is vice degree. Bharat.
Vice degree.
It's there in our.
Yes, Mr. Solicitor General.
Perhaps attorney wanted to say
Fully agree with Mr. Dhawan that if regulation is invasive, which denies right under Article 30, the regulation would be bad. There is no quarrel on that. But I am taking your lordships to a different point of view.
Yes.
Lord, your lordships are examining the law laid down in Aziz Basha, where Aziz Basha, my lord, examines the law which is enacted by the Imperial Parliament 103 years from today. We are, my lord, traveling back to it's 2020. We are in 2024. Lord, Aziz Basha will have to be understood in the context of the historical background in which Act of 20 was passed and historical background in which Aziz Basha was decided. Because my respectful submission is, Aziz Basha does not lay down a law of any universal application, nor does it lay down any ratio which the petitioners have understood.
Yes.
The petitioner's main argument was that Aziz Basha lays down that once you are established by an act of competent legislature, you can never become a minority institution. And the logic behind their submission is, and rightly so, if that is the ratio, but it is not, that now UGC Act requires that a university can be incorporated only by an act of parliament or competent legislature, and therefore there can be no minority institution, a minority university. That is not the ratio of Aziz Basha.
Yes.
So there was a particular regime in place during which, my lord, this movement started of establishing universities. That is somewhere in or before 1920. There were educational institutions either recognized through an act of the imperial legislature or otherwise. There were several universities, several institutions which had no blessings, Lord, of the imperial legislature. Lord, there were simultaneous two streams which were going on. One was, and we may not forget, my lord, 20s were the years where the freedom struggle was at its peak. One stream was that no, we will have our own university and we will not depend upon the British government's legislative competence or legislative power. The nationalists, my lord, they are historically called the nationalists. Without meaning any disrespect to the other group, that's how they are described. Second was that no, we must have an act of the imperial legislature so that the degrees are recognized where in the employment of crown, degrees of non-registered universities were also recognized, but not in the services of the British government. and not, of course, outside the country.
Yes.
So having more than one options and several, in fact, the majority, like my lord, Vishwa Bharati University, Shantiniketan. Shantiniketan was an institution. It had no blessings of the British government. It became university after UGC. And it was granting degrees, and their degrees were valuable. IIT Roorkee was an institution without any imperial legislation. You had that option.
When was IIT Roorkee set up actually?
1857. The name was different, Thompson College of Engineering, but 1857. Thereafter, in somewhere in 30s, it became IIT Roorkee, but remained unaffiliated. Lord, what I'll ultimately, Lord, I'll just say the end first and then take your lordships to the historical background. There were two simultaneous streams going on. I'm sorry. My lord, those who were in favor of, so far as this university is concerned, those who were in favor of accepting the conditions imposed by the British for the purpose of passing an act and making you an university. And the second, that no, we will continue with our minority Muslim status. We will not succumb to the British. We don't wish, because Britishers were saying that if you want a university status, you will have to give up some of your minority status. It would be a kind of neutral or a kind of a secular network which we will provide.
Not just minority status, but your cultural status as well. Could be a non-minority cultural status which you are claiming.
That I'll show. Those who were in favor of having a university called Aligarh Muslim University under an act of imperial legislation, provided for that, and an act was passed where they surrendered many of their rights. And those who were confirmed, who were very sure that no, we will not, it would be an Islamic institution, they in 1920 from the premises of Aligarh Muslim University declared Jamia Millia Islamia. Jamia means university in Urdu, Millia means national, and Islamia means Islamic. They continued their status as minority institution the way they wanted without surrendering anything, and they were registered after the UGC Act came into force. They were recognized. I'll take your lordships through that. Therefore, my lord, the ratio in Basha is that at a time where there were no fundamental rights, there was no Article 30, you had a choice of either not surrendering your rights or surrendering your rights and get an act of parliament, imperial parliament. You chose to surrender, and therefore it was established when it was passed by imperial legislation. And in 1920, there was no Article 30. So it was a voluntary surrender. Today, I cannot be asked to surrender my fundamental rights. But Britishers did, and they could. And everything is documented. And documents are on record from the beginning. What I have done, my lord, I was told my learned senior Mr. Singhvi's, Mr. Sibbal's objection that I have placed some new documents on record. They are, my lord, acts of constituting or incorporating several universities. I'm not going to read them, but I don't wish to be accused of suppressing something. My lord, the way they did, they placed on record, my lord, 3rd September 1965 debates without placing 2nd September. I have placed everything. I'm not going to read them. Now, please see, my lord, my note 2F. And my lord, kindly examine Aziz Basha in this context, my lord. not 2F, my lord, page 1. I'm sorry, volume 2F, page 1. This was the regime in place where 1920 Act was passed.
Just one minute.
Volume.
This is Roman 2.
My lord, Roman, sorry, my lord. Roman 2F, but I'm sorry, my lord. I then corrected. I should have
It's the last one.
said Roman.
Last one.
Will, my lord, with your lordship's permission, we'll change it to 2B1, my lord. I think it was 2B, it should have been 2B1.
But 2F, it should be numerical 2.
Done by someone else. But anyway, I'm not. But does your lordship? I'm sorry.
Vishwa Bharati came before UGC.
Much before. Vishwa Bharati University. Shanti Niketan, obviously.
Niketan was
much
there,
before, but
But
I just.
Vishwa Bharati University came sometime in 1951,
No, it was by an act of Indian Parliament.
Indian Parliament.
Yes, sir, your lordships are right. I stand corrected.
You said after UGC
No,
Act.
no, not. It was before that. I stand corrected. I have, my lord, that year also and the act also. Shanti Niketan, of course, my lord, was started by father of Rabindranath Tagore, but expanded and Lord, it reached its glory during the period of Rabindranath Tagore.
And we'll also sort of trace, I mean, those universities are not in question before us, so therefore we are not at all going to be commenting on them.
Yes.
But institutions which did get minority status, what was the course which they followed? What was the path which they followed? And you may want to make a distinction with AMU if you are that's your line of argument.
Lord, the question of minority status came only after the constitution came in.
Right.
Lord, I have not weaved that also.
All right, we'll see how that.
But Lord, we would be doing injustice to Aziz Basha unless we read it in the dehorse the context and the regime it was available. Because just, my lord, this cannot be an argument, I am aware. But, my lord, just out of curiosity, I just examined. Lord, Aziz Basha is 65 judgment, 1968 judgment.
68.
1968 judgment. The honorable judges, this is not an argument, and please don't take this as an argument, must be around 20, my lord, when 1920 Act was passed. Their age. They must be aware of this history, especially the author of the judgment. He was from Uttar Pradesh. Because this is the background. This was, my lord, a very hotly debated issue in the country. This was a part of Khilafat movement. Ali brothers, my lord, who separated and made Jamia Millia Islamia.
He was one of the few remaining ICS officers. He was
possibly the only chief justice without any legal background.
He was an ICS officer.
He was an ICS officer.
Mr. Dr. Dhawan, right? Mr. Justice
Yes.
Malaknath, the advocates were in the majority and the ICS officers were in a minority. Very interesting about Golak now.
That-
All of them were in the minority.